I'm a practice area lead with LexisNexis, and today we are speaking with two speakers today. They are Samuel and Keong from Legis Point LLC's dispute resolution practice group, which Samuel's heading the group. So they are going to be here sharing with us their thoughts on the legal impact of COVID-19, particularly in the construction, finance and banking, as well as logistics sectors. So Samuel and Chacko have both contributed to a number of our publications, and I've worked with them on the Atkins Court Form Singapore, as well as the employment volume of Halsbury's Laws of Singapore. So I'm very honored to have them here today to share their thoughts with us. And since this is a live chat session, so you can submit any burning questions you may have by clicking the Q&A button at the bottom of your screen. And we may go through some of the questions along the way as best as we can when we have the time. So let's get started. Samuel and Chacko, welcome, and thank you for taking the time to join us here today to share with us your thoughts. So since we're talking about a legal impact of COVID-19, right? So let's start by talking about, the COVID-19 Temporary Measures Act. Can you share with us, tell us a bit more about how the act come about, and also what are the nature of measures implemented under the act?
Thank you, Shelley. It's a pleasure for both Shaq and I to be here with you. Maybe I can start off by talking a little bit about the genesis of the Act. And really, we live in unprecedented times, and perhaps short of a world war, we are in a situation which is incredibly difficult and unprecedented. And the reason for the COVID-19 Temporary Measures Act was explained quite clearly by the Minister of Law, Mr. Shanmugam, when he said at the second reading of the bill that what they are bringing about really is a hard stop, an immediate stop by government orders to most economic activity, even movement of people, overnight as it were. And so the impact of that on the economy is literally one of free fall. And I think you saw the impact of that free fall just a few days ago when the government announced the drop in our GDP numbers, quite unprecedented, 41.6% drop in the second quarter alone. And the reason why that's happened is because travel has stopped, economic activity has stopped, interaction between people have stopped, shops have had to close, and the list is endless. And in that sort of environment, the basis on which people do business has become completely different from what was originally envisaged. And that was really why the government then enacted the COVID-19 Temporary Measures Act. And essentially that act is to give some breathing space to businesses, to contracting parties, to try and get their sort of situation under control over perhaps a period of 6 months before strict contractual rights are enforced. Right. And as the Minister of Law actually said, look, if you allow people to strictly insist on their contractual rights, it's just going to be chaos. Some people will benefit, lots of people will suffer, and therefore really there has to be a balance struck. So what the Act does really is for a defined, in fact, a narrowly defined category of contractual relationships, there is something of a temporary stop, a breathing space created. And these essentially will be leases, licenses of non-residential property, construction-related contracts, event and tourism-related contracts, hire purchase or conditional sales agreement, and certain types of loan facilities. And the window is fairly narrow. You're looking at any obligations that has to be performed from, on, or after 1st February, right up until 19th October. Those obligations, in a sense, are put under a separate sort of scheme, so to speak. They are protected. And come 19th October 2020, this sort of bubble that's been created will be lifted. And then parties will be at liberty to pursue whatever rights they have under these contracts as they deem fit, subject, of course, to any further enactment that Parliament may see fit to pass.
Right. So, now that we talk about how the act came about, and also let's go into the specific examples and issues that we would like to cover. So, in terms of finance and banking, so for banks or financial institutions, so what are the steps that the financial institutions can take? Let's say if their borrowers, maybe the businesses, if they can't repay their loan, or they can't make the repayment in accordance with their terms in their loan agreement. Does the act sort of affect their ability to take any action during this period?
Yeah, actually, if I could, like to comment on that question. Just picking up from where Samuel left off. Now, one of the features of the Act is that it creates, a sort of scheme for disputes, right, to be resolved, because the Act creates a system for people who have been affected by COVID-19 to seek relief. And the way they do it under the Act is they serve a notification for relief on their counterparty. The counterparty can accept, right, the notification for relief, in which case, the obligations are postponed until the end of the prescribed period. Or if the counterparty disagrees, then the dispute, right, is then referred to an assessor. And the assessors are empowered to resolve the disputes and make fairly quick decisions, because the idea was not to allow the courts to be clogged up, right, with these disputes. And the assessors are appointed by the Ministry of Law, and the assessors will probably take their cue from the what the law minister said at the second reading, that it's the idea is to spread the pain, so to speak, and not to allow the economy to sort of bottom out. Right? So coming to your question specifically, on financial institutions, from the perspective of the financial institution, what they have to do is to see if the particular credit facility is covered by the Act, right? Now, then the question is, what types of credit facilities are covered by the Act? The first thing you have to look at is the type of borrower. Okay? The borrower must be at least 30%. The shareholders of the borrower must be at least 30% Singaporeans or Singapore PRs, or if the interest, right, in the entity must be at least 30% owned by Singaporeans or Singapore PRs. The turnover of the group, right, of the borrower must not exceed 100 million in the previous financial year, that is financial year of 2019. Okay, so that's as far as the borrower. The second requirement, right, is the type of loan. Now, if the loan is secured, right, by property that's located in Singapore, in industrial or commercial property that's located in Singapore, then it would cover it. Or if the loan is secured by plant, machinery, or fixed assets that are located in Singapore and are used for production or manufacturing or business purposes, then those types of loans are also secure. So the financial institution have got to assess whether the particular borrower comes under that particular profile, and whether the particular type of loan comes under that type of profile as well. And then the third thing that the financial institution has to look at is whether a notification for relief has been served. All right. So if all three requirements are satisfied, then the borrower can take advantage, right, of the reliefs that are given under the Act. So if I were a borrower, if I were a lender, right, what I would do is I think in there are possibly 4 situations where a borrower could still try to recover, take some form of recovery, or try to enforce the security. One would be where the borrower is a foreign entity, right? By which I mean, where the shareholders or interests, right, belong to foreign entities or foreign.
Yeah, so it does not fit that criteria that
That's
you
right.
mentioned, right?
That's
Yeah.
right, exactly. Or even so, if the borrower is a foreigner, in that case, even if the security is land in Singapore, you could still say, you're not covered by the Act, and I'm going to try to seek recovery or enforce, right, my security. The other situation where a financial institution could think about recovery is where the dispute resolution is by way of international arbitration, right? Because that is one of the mode of proceedings which is not prohibited, right? Even if you serve a notification, even if the borrower to serve notification on the financial institution. The third instance would be where the financial institution takes the view that the borrower's inability to pay is not caused by the COVID-19. All right, because for the relief to accrue to the borrower, the borrower has to show, right, that his inability to pay was caused by COVID-19.
Right.
Now, that is important because the treatment, right, given by the Act, right, to construction contracts and tourism-related contracts and event contracts is different, right, from the treatment given to credit facilities, recovery under credit facilities.
Right.
I'll give you the example. In the Act, right, it's provided that if, right, the inability to perform is materially caused in a construction contract, if the inability to perform is caused, right, or materially caused by COVID-19, that in itself is a substantive defense to any claim, right, in relation to the inability to perform. And in relation to tourism-related contracts, right, if the claim is for cancellation fees, right, the defendant can say, look, it was caused by COVID-19, and that, according to the Act, is a substantive defense. So it's not just saying that you can't sue me until the prescribed period is over. It's actually giving you a substantive defense.
Right.
Now, that kind of provision is not made for credit facilities. All right, so that is significant because if the financial institution can show, right, to the assessor, look, it was not the inability to pay, right, or the non-repayment of the loan is not caused by COVID-19. It means that the financial institution is in a fairly strong position to try to enforce its security.
Right.
So that is, I think, one of the key things that the financial institutions want to look at.
Okay. Well, thank you for that.
If I could just jump in there and add. So effectively what it's saying is that if you have a notification issued, the financial institution can challenge that notification.
Right.
And then it goes before an assessor. And if the assessor finds that the inability to perform is not caused by COVID-19 or is not an obligation that falls to be performed after 1st February, then there is free rein to the financial institution to proceed to enforce.
Right.
The financial institution can also enforce security over assets which are either not immovable property, or if it is movable property, not movable property that is used in the trade or the profession or the business. So it's not a blanket prohibition. You've just got to look at those.
It's not a free pass, basically.
That's right.
Right. Okay. So, so Chacko, you also mentioned about the construction contract, right? So, can we talk a bit more about also, like, in terms of construction contracts, what are the specific reliefs these subcontractors actually, they are available to them? Because of the COVID, they are unable to complete their project because of the disruption of, manpower workers. So, what are the specific reliefs that are available to the subcontractors?
Sure. My colleague Sam is the expert on this area.
Oh, right. Okay.
He
Thank you,
sits on
Jack.
that panel, so he so far. So I will defer this question to him.
Sure, sure.
Well, I'll take it up from there. Well, the first thing I would do if I were a subcontractor would be to issue a notice under the Act to say
Yeah.
that I can't perform because of a COVID-19 related event. And in my notice, I would be fairly specific about what has happened which has prevented me from performing, because ultimately you should anticipate a challenge to that notice, and you want your
Yeah.
notice to have all the necessary information so that when it goes before an assessor, your position is already flagged and out there. So what I would do if I were a subcontractor would be, first of all, to identify what are the events related to COVID which prevents me from performing what I am supposed to perform under the Act. I would then, if there is a performance bond issued, serve that notice also on the issuer of the performance bond or the guarantor. This will benefit me in the sense that if there are liquidated damages, that's suspended. If there is time frames which fall within the 6-month window between February and October, that is to some extent suspended and not taken into account. So in a sense, it's like as if this period of time has just disappeared. And then the contract continues after October as if those 6 months didn't exist. There is some academic debate about whether once you invoke successfully that notice under the COVID Act, whether that's really an extension of time, because if you take it as an extension of time, there may be issues about additional preliminaries and so on and so forth that may come into play. There's not been any case that's been decided which sheds light on this, but these are issues that will crop up. So what the contractor should do is straight away issue his notice. If that notice is not challenged, well and good, because then it creates, to some extent, some sort of binding sort of position between the parties. If it is challenged, it goes before an assessor, no legal representation. Parties have to go and present their own cases. The assessor decides, and his decision is binding and non-reviewable. And if he finds that the contract has been affected by COVID, then you can't sue on the contract. You can't claim breach of contract for that window. You can't claim liquidated damages. And if you do sort of commence proceedings, that might even be an offense under the Act. So the Act actually gives parties who are unable to perform fairly strong protection. Of course, at the end of that 6-month period, when that sort of cushion is lifted, then it becomes fair game. And then I think parties will start taking action, commencing proceedings, and sort of pursuing their full contractual rights. Of course, within that 6-month window, a subcontractor who is owed money can also pursue his claim for payment under SOPA, Security of Payments Act. The COVID Act does not suspend the operation of SOPA. So if you have a claim for construction work which has not been paid, you can actually make a claim under SOPA and go for adjudication. That process is not stayed, it is not interrupted, and you can actually get an award. However, when it comes to enforcing that award, you might have that problem in that if it goes into a court, you might end up with a stay of that enforcement until the 6-month period is over. So subcontractors who are owed money would, I think, be very prudent to get out there and get their SOPA applications out and have at least determinations rendered in their favor. Even if they can't enforce it, at least they have it in hand so that at the end of the 6-month period, they can make a dash for the line and try and get whatever is due to them under those awards. If you've got a bank guarantee or a performance bond, there's a prohibition if you've issued a notice on calling that bond, save for if that bond is going to lapse within 7 days. And the idea behind that is to give parties an opportunity to negotiate and arrange for the extension of that performance bond. And only if that performance bond is not extended can the beneficiary of that performance bond actually call on that bond. So again, there is some effort put into these provisions to ensure that parties negotiate, talk, and try and work out a compromise which balances either party's interests as far as possible. There is also no restriction if your construction contracts have either force majeure clauses or frustration clauses. You are not precluded under the COVID Act from pursuing or availing yourself of remedies under these provisions. So, for example, if you have a force majeure clause which covers the COVID-19 situation, you can invoke it and, in a sense, seek to protect yourself from any breach or potential breach of contract by saying, I'm excused from breach because force majeure applies. Frustration, however, is a little harder to establish because the test is pretty rigorous. You really got to show that the performance of the contract has changed by virtue of the circumstances, that now what you're performing is a contract that's completely out of the anticipation or the expectation of parties. It's a different contract that you're performing because of the supervening events. And that threshold is really quite difficult to prove and establish in a court. So while you have force majeure and frustration provisions applicable and enforceable in this interim window, much will depend on the specific provisions of the contract, and to what extent you can show your inability to perform was really impossible as a result of the measures taken under COVID.
Right, so it sounds like it's not as clear cut in if you were to use the force majeure and frustration clause, right? So, you know, yes, sorry, Chacko.
You have a situation where, one side is accumulating liquidated damages. Mm-hmm. The other side is saying, I've done this amount of work.
Yeah.
So it might depend on how much is owed on where you are, right?
Right.
And don't forget, if you want to raise or say the contract is frustrated, the loss lies where it falls, right? So if you're owed this amount and LD is only this amount, you might not want to say it's frustrated because then you can't collect on what you're owed, although you don't have to pay the LD. But net, you're in a loss position.
Right.
The advantage for a subcontractor is that if you can show that your inability to perform or during the prescribed period was caused by COVID-19, that's a defense. So you don't have to go to the route of frustration. Right? So you can say, look, I've got a defense on the LD, right? Because the Act gives me that defense, but you still owe me for the payment for the work that I've done. So that's one way of looking at it.
Right.
Much will depend on the specific situation that the particular contractor is in.
Right. Okay.
What do you think, Sam? You think that's...
Yeah, I think that makes sense. I mean, if you are going to invoke frustration, you would only probably invoke it if your liabilities are higher than what you can expect to claim from the other side, because, as you say, the loss lies where it falls.
Mm. Okay. So, continuing on the COVID-19 temporary measures, I know it doesn't cover the logistics industry specifically, but, what happens if in a business in this sector, logistics sector, supply chain, they experience, a decline in the revenue and, they have insufficient funds, and are there any measures that will help these businesses, to prevent them from going ahead from insolvency proceedings?
So can I take that question? You're right that there's the logistics sector as such, right? It's not covered directly, but there is a segment which covers supply contracts under the Construction Industry Act. So that sector is at least given some protection. The rest, unfortunately, is not, or depending on where you are on this chain, right? Yeah. So if you don't fall under those contracts which are protected, the Act does still give you some protection, because bankruptcy thresholds have been raised, right? It's now 60,000, right? It was previously 15,000, so it's quite a substantial increase. And for companies, the insolvency threshold has been raised to 100,000, right? Previous threshold was 10,000, right? And the time given to you, to the debtor, right, to set aside the stat demand has been increased to 6 months, right? It's previously 21 days, right? So, but, if you still owe a lot of money and, it may not really help you at the end of the day. So what you might want to do is take advantage of the moratorium that's been given, while the debt is accumulating, right, before it reaches the threshold. It makes sense for the debtor to approach his creditors and to try to work something out. Because anybody who hopes to make full recovery in the current climate, right, is not being very realistic.
It's a very steep hill.
That's right. That's why the act has been passed, is to make people, businesses, right, creditors and debtors come together to try to, reach a compromise. The other thing that, such businesses who are not covered specifically, right, the other thing they can do is avail themselves of rentals, support that's been given by the government. Right? If your group turnover is less than 100,000, you have 2 months. Right? And if your business or revenue has dropped by more than 35% compared to the same quarter of the preceding year, you have another 2 months. So that's 4 months altogether. The current COVID Act doesn't cover this rental reliefs yet. I understand that it will only be enacted end of July. Right? So that's why there's some confusion, currently about how the scheme is supposed to work. And we also understand that what will happen is they will have a scheme, right, where the accumulated rentals, right, that arrears, instead of having to pay it on one lump sum, there will be a scheme where you're given up to 9 months, right, to pay in equal installments, and the interest will be kept at 3%. So it makes it easier, right? Doesn't make it easy, but makes it easier.
Yeah, to buy some time as well. I think that's very important.
At the end of the period, and you have to pay all the arrears in one shot.
Yes.
Yeah.
I think what it really allows is for businesses, hopefully, the time to recover during this period, right?
I think business owners have to, consider carefully. I mean, they will have to make a judgment call whether or not the business is going to survive.
Right.
And I mean, conditions for business have changed drastically. So all the business owners have to take a hard look at, their model, their business model, and decide, whether it is a viable model still, right? And it's a very fluid situation because, Anthony Fauci, the expert, right, on communicable or infectious diseases in the US have said, you could see a vaccine by December of this year, right? So hopefully that happens, and then we go back to what life was before this started. But if it doesn't, then I think a lot of people have to look at how their businesses function and whether it's still viable, right? And if it doesn't, it might be better just to stop the bleeding.
Yeah, I mean, continuing that along that line about this conversation, right? So, a lot of these measures are, as the Act says in the name, right? It's a temporary measures, but be it or not, whether we have a vaccine at the end of this year, I mean, some experts have said as early as even next year now. What's undeniable, I think, is the economic impact of COVID-19 is going to be even longer term than, for a lot of these reliefs are going to be until October. But for, beyond this period, beyond this 6 months period, what can businesses do, right? If even with all these measures are lifted, they find themselves in a situation that they are still unable to repay their debts. What would be your advice, I mean, Samuel and Chacko, for businesses, what kind of practical steps they need to take?
I think that the time is now really for those businesses to start talking to their creditors. Nobody's expecting to be paid 100 cents to the dollar at this stage. Right? So it's really being realistic about where you are or where we are in the economy, and try and work out a compromise. Right? Because what we have is currently is for financial institutions, what normally happens is if you have a distressed business, but it's still a viable underlying business, somewhere there, you have a standstill, right, before your bankers, and they give you some breathing room. And this is the breathing room which the Act has given to businesses. they've raised the thresholds, they've stopped court actions. So now's the time to start talking, right? To take advantage of the standstill that you've given, and try to reach a compromise with creditors, right? The MES has said that in today's Straits Times, MES has said that most likely they will not. We will not see a situation where all the relief suddenly disappear at the end of the prescribed period on 20th October. So they might come up with more measures to try and help businesses that are viable, right, to stay afloat. But I suspect it will be less assistance than what we have currently under the COVID-19 Act.
Yeah, I mean, I think judging by what one of the ministers has said recently, that further government relief may not help the situation, given that the pandemic is worldwide and just throwing money at the problem may not solve the problem. So I think businesses need to anticipate that at some point, the government may not be in a position or may be unwilling to continue the very generous grants and support that they have given over the last few months. That, I think, practically requires businesses to take, as Chacko says, a hard look at their business model to decide whether it's viable, and where they have accumulated debts, perhaps work out some sort of arrangement, maybe try mediation or some alternative dispute resolution mechanism, which allows them to enter into some form of agreement which provides for staggered payments or payments over an extended period of time. Hopefully, the government will not allow that 6-month sort of temporary respite to lapse just all of a sudden and drastically or dramatically, and will allow some sort of time frame over which these measures will be slowly eased, so that businesses will not be faced with a huge mountain of debt at the end of the 6 months with no capacity or capability to pay it immediately.
Yeah.
So
well,
it's still very uncertain because we don't know where the government's going to sort of come out with legislation, but I think we just need to keep an eye on things and at the same time start talking to your creditors and try and work out some sort of resolution.
Yeah, well, I think that's really sound advice. And thank you so much, Samuel and Keong. Time really flies. We've actually come to the end of our session. So I'm sorry, everyone, to all our attendees. We didn't really have time to take in any questions. But if you do have questions at the end of this session related to what we have discussed, or even if you want to reach out to Samuel and Keong, you may do so directly. So thank you once again, Samuel and Keong, for taking the time to share with us your valuable thoughts and perspectives on this. And to all our attendees, thank you very much once again for joining us in this session.
Thank you for having us.
Thank you. Goodbye.
Thank you. Bye-bye.